Number 49, the people of the state of New York versus Stanley Hardee.
Good afternoon, Your Honors. Rachel Goldberg on behalf of Mr. Stanley Hardee. I'd like to reserve 2 minutes for rebuttal.
2 minutes, Ms.
Yes.
Goldberg?
Thank you. There is
Counsel, why isn't it a mixed question?
Because there is no record support for the appellate division's finding that the search was reasonable. There was absolutely no
Do you
indication of a
agree
weapon
it's a mixed
here.
question? You're just saying that there's no record support for the finding.
That is the argument. There was no indication of a weapon, no indication that Mr. Hardee was going to use it. So the question is, in a totally routine traffic stop,
But was it routine? One of the things that struck me in comparing this case to other cases is the fighting that took place, the struggling over handcuffing them. That seemed to have elevated because it seems in Mundo and Carvey, the other cases seem to specifically use the phrase, the police acted in the situation without incident. The without incident phrase comes up a number of times. And so here, there was incident. There was a struggle going on. Now, the record's a little unclear, and when I looked at the trial court's decision, it seemed like the discovery of the gun took place almost simultaneously as the struggling was taking place with the other two officers. But then it took 3 officers to subdue them. So wouldn't that be enough? Wouldn't this elevate it then?
well, to start, nobody ever claimed that the handcuffing had begun before the search. In fact,
I didn't say before. I said simultaneously. So let's talk about the scenario that I presented to you. Is this without incident? Is the struggle without incident?
Mr. Hardee was acting in a way that could raise the suspicions of the police officer, but there was still nothing to indicate a weapon in the car, and that is what's critical. That's what's
What do
critical.
you have to do to indicate a weapon? I mean, you know, in a lot of these circumstances, I think that the same conduct could be indicative of drugs or, you know, other illegal things in contraband or a gun. So how do you make that distinction? What does it have to be to show that there may be a gun?
So something about, so the appellate division here focused on Mr. Hardee looking into the back. And so there had to be something indicating something dangerous. There was nothing like that here. In
The problem
Carvey,
is
there was
that the cases seem to fall on this spectrum. You know, it's easy when somebody has a bulletproof vest on. I forget which. You can tell that there's maybe a gun involved if there's a bulletproof vest. But in other instances, it isn't quite that clear. So, and it's inherently a subjective analysis that a police officer is making. It's confined to them reacting to an emotional situation, also with the accused party, all simultaneously. And that's why once we move to incident, where there's some incident taking place, it's tough to see how this isn't a mixed question.
Because, so Sergeant Sinai and Kaler did exactly the right thing. They ordered Hardee out of the car, and then they frisked him and they brought him around to the back to protect their safety. And so there has to be, the law is very clear, in order to go back into that car after he's been removed, he's 3 feet away, there's nothing in his grabbable area.
But you have another person involved in this case, right? You have the fiancé who's also being taken out of the car at the same time?
There was no suggestion or argument that she posed any kind of danger.
But this is the reaction. It's not now we can say, you know, she didn't pose any danger, it wasn't a gun, it was a gun. At the time, they have someone who's engaged in odd behavior, who they take out of the car, as you say, legitimately, who at some point, and it's not clear, but it certainly is an inference that it's simultaneous, starts to struggle and resist while you're taking another person out of the car. And what it is, it's just facing what's not a mixed question about whether or not they were justified then to look for the gun.
Because the belief that there was a weapon in the car is completely unreasonable. I mean, there was no concrete indicia of a weapon here whatsoever. Even if you thought, even if it was
Absent a bulletproof vest, the example we have, what would that be?
So in Mundo, we had somebody who was using his car as a weapon to evade police, almost hit somebody,
A weapon in the
stashed
car,
something.
what would that be if you're not wearing a bulletproof vest?
So trying to hide something in conjunction with really dangerous behavior.
But that could be drugs.
It could be, but coupled with this other extremely dangerous behavior, it is substantially likely, it's reasonable.
You know what I worry is that the substantial likelihood test becomes basically a plain view test. Then they have to actually see either a weapon or some other accoutrement that's used with a weapon, something that's used with a weapon. And that can't be the test. That would be far too narrow. I don't think you're really arguing for that.
Right.
You're really arguing, as I understand it, that under the totality of circumstances, this didn't meet a minimum legal standard. And so, and that's doesn't require the scene of a gun or the viewing of the gun. It requires an analysis of a series of factors, and then the court has to determine whether or not a basic evidentiary level has been met here. And so it's slightly different, because if you were to argue for the scene of the gun, there would be no stop or no search that would ever be justified.
Well, we have Carvey and Mundo as examples. I mean, nobody saw a gun there or a knife or any other kind of a weapon, but what they did have was an obvious secretion of something that the person didn't want police to find, coupled with really actual specific moves that the person made that were really dangerous, in Mundo, for example. So there were much more concrete things than this sort of mushy nervousness.
There's a little bit more than nervousness here. I mean, he was looking, he kept looking in the back of the seat. I mean, that's certainly indicative that there's something there that he's worried about being there.
But
So what more does he have to do to indicate? Is it because he didn't show a disregard for the safety of others? Is that what
that's a big part of this court's rule in the line of cases, is an actual demonstration that you were willing to use a weapon. Here, he was...
Use a weapon, or, as Judge Stein is saying, disregard for the safety and security of others, because don't you satisfy that here? Because the reason he's stopped is he's speeding, whatever it is, 30 miles above the speed limit in a residential area of Manhattan, late at night.
But we already allow police officers to order people out of the car in a recognition that, somebody who is violating the traffic law, the police need to be able to see
No, I understand, but there might be a difference between going through a stop sign at the regular speed limit or making a right on red where you're not allowed to do so, and speeding for several blocks, 30 miles above the speed limit, which I think you would agree is particularly dangerous to pedestrians and anybody else, and drivers, anyone else on that road.
But it doesn't show a willingness to break the law in conjunction with all these other things that are required, like,
You mean it
some
doesn't suggest
indication-
violence?
Right.
Is that what you mean?
Right.
You know what strikes me, though, in the sequence of events, and it's the record isn't entirely clear. I think you're right about that, but that he doesn't begin to struggle until, I guess it's officer, begins with an L, loud, begins to remove the other lady out of the car. So as one police officer gets closer to where the gun is, that's when the struggle starts to take place. I don't know if it was a fight. I think it was more of a struggle over cuffing. And that's will be, I would think, a normal reaction if the police officers are getting close to the gun. That seems to be illogical.
It was, but there was no testimony that anybody thought he was going back into the car, which is the standard. And the,
He was
even if...
not going back into the car, or there was testimony, though, that it looked like he was trying to map out a route to flee or possibly make a break and, who knows, get back into the car, because he was looking at various corners or something like that. That was the testimony, as I recall.
But that's the theoretical test that this court rejected in Torres, because there was nothing specific to tell the police that there was a gun in the car, that the person was going to, or any kind of weapon. I mean,
The officer who actually searched for the gun, what did he testify was the reason that he went to search? Did he say it was because he saw the defendant resisting arrest? What did he say?
Sorry, the person who went back into the car?
The person who actually searched the bag.
He said it was because Mr. Hardee was frisked, because he was looking around the car and initially refused to get out of the
Say anything
car.
about the resisting arrest, the handcuffing, the movement during the
He said
handcuffing?
movements in the back of the car, looking into the back.
But not anything related to the cuffing?
No.
or
In
the
fact, he
resisting?
said if he saw a struggle, he wouldn't have searched the car. He would have come to help his fellow officers.
Thank you, Ms. Goldberg.
Thank you.
Counsel?
May it please the court, Jessica Olive on behalf of the people. This case presents a standard mixed question of law and fact that is beyond this court's review because there is ample record support for the lower court's decisions. Specifically,
First, if we start with assuming, which I don't know if this is the case, but if we start with assuming that the question isn't about the minimum standard, which of course would take it out of that mixed question rubric, but what specifically do the people point to in showing this specific reason to suspect that there's a weapon in the car?
absolutely, Your Honor, this case clearly meets the minimum threshold for this legal standard based on the totality of the circumstances, if I may go through those facts. You start before they even pull him over. It's in the middle of the night. He's going almost double the speed limit. He's quote-unquote flying down the street.
There's no testimony that there were people in the street or that anybody was endangered.
Well, actually, the officers testified that he's weaving in and out of traffic, so therefore you can infer that there are, in fact, other cars on the road at that time. And at the point that they pull him
So
over...
everybody who's speeding,
I'm sorry?
everybody who's speeding, you get to check everything inside their car?
No, Your Honor, this is assessed under a totality of the circumstances. That is one factor among many others that justified the search here.
Other factors here are?
Once they pulled over the car, defendant was wide-eyed, animated. One of the officers thought he was high. His head is spinning around the car. He's looking to the back of the vehicle 2 to 4 times. And Officer Loud testifies that when he leans down to look into the car, he sees that defendant is looking over his right shoulder, behind the front passenger seat, at a shopping bag.
Can I just ask you about Torres for a minute? Because in Torres, we said a police officer acting on reasonable suspicion that criminal activity is afoot. That's the first part of it. What was the reasonable suspicion that the police had here of criminal activity?
Well, Your Honor,
Isn't there testimony from the record that they would not actually have arrested him? That was not their plan at the time they took him out of the car.
Your Honor, the officers don't require reasonable suspicion to stop a car. They can
I understand
stop
that.
the car
This-
for
this is
traffic
from- This is
violation.
from Torres about the circumstances in which you can search a vehicle incident to a stop.
Yes, Your Honor.
Was there a
Torres-
suspicion of criminal activity? Did the officers have that at the time? And if so, what was it?
Well, Your Honor, based on the totality of the circumstances, they had reason to believe that there was a weapon in the car that was presenting a danger to the officers. And that is the standard that Torres eventually set forth.
That's the second part of the test, right? That they
The
have to have some concern for their safety.
Torres set forth a distinct test for protective searches of vehicles compared to people. It first laid out the test for a protective search of a person. And in that context, you have to stop the person based on reasonable suspicion and then have reason to fear for your safety. The court in Torres said, well, actually, for searches of cars, we're going to require probable cause unless you can show a risk of a weapon in the car that presents an actual and specific danger to the officers. So Torres was rejecting the theoretical basis test that was set forth in Michigan versus Long. They're saying we need more. We need something more than just the idea that he could gain entry or gain access to a weapon upon reentry to his car.
What was the more here, counsel? You mentioned him looking over his shoulder back at the back of the passenger seat. Is that it? Is that the more, or is it the resisting arrest? Is it also?
It's a totality of the circumstances analysis, but the fact that he repeatedly looked into the car and he actually disregarded the officer's orders 3 to 4 times to stop looking around, stop moving. He disregarded their orders to get out of the car and continued to look behind this front passenger seat and into the back of the car. It's analyzing all of
He came out
these.
peacefully, right? He came out peacefully.
The officers had to tell him to get out of the car
3
3 times.
Right. And he didn't argue with them. He just didn't do it until the 3rd time, and then he got out.
He got it, yes.
And they chose to bring him around to the back bumper of the car, right?
That's correct.
Is there any indication in the record that they couldn't have brought him further away from the car to question him if they were concerned about a weapon?
They would have certainly been entitled to take that safety measure, but
Can they create this need for a safety measure of searching the car by keeping him close to the car where that risk is?
well, Torres actually it sets forth a standard that is quote-unquote notwithstanding his inability to gain immediate access to that weapon. The whole concept is that there is an articulable facts that you can point to that once the investigatory stop is terminated, once the traffic stop is terminated, that he's a dangerous individual and he may go back into that car and gain entry to a weapon. So
What if the record shows that Officer Loud was already simultaneously in the process of searching this car and looking into this bag at the same time as the defendant starts resisting the handcuffing? If you can't consider the handcuffing as part of this, does that end the case there?
no, Your Honor, there's still a variety of factors that justify the search here, even once he's out of the car and they frisked him. So clearly they sense some danger, and defense counsel is not contesting that that wasn't justified. He also continued to look into the car after he's out of the car.
That seems to be one of the major factors that everybody is relying on here, is the looking around. So what that leads me to, and I think I asked defense counsel this as well, is how do you distinguish between, I mean, somebody may be nervous and looking around the car for a lot of reasons. This person had an open container of alcohol in the front, which he apparently was nervous about, right? And maybe he had more alcohol in the back. Maybe he had drugs. Maybe he had stolen property. It could be any number of things. What is it that rises to the level of articulable suspicion that there is actually a weapon there? Is it just that he's looking nervously around in the car and in the back seat?
Well, Your Honor,
I add also because the cop who's closest to him says he thought he was high, and that might be a reason for the jitteriness.
well, Your Honor, his preoccupation with a specific area in the vehicle, that's analogous to this very well-established case law that where a defendant is shown hiding something in the car. And it's the same exact thing, because it's an indication that he's concealed potentially dangerous contraband in that area.
We're looking at the trunk of the car, which was closed, instead of the back, into the back of the car. Would the police be able to lift that trunk up? Because I think there might be no, they wouldn't.
No, that wouldn't fall under the Carvey-Mundo exception, Your Honor.
Where was the bag?
Where was the bag?
Where's the bag?
It was on the floor behind the front passenger seat.
Does anyone say he's looking at the floor, at the bag, before they decide to search for the bag?
Officer Loud testified, and it's on page 142 of the appendix, that it appeared to me he was looking at that bag. And if you read pages...
At what point did it appear to him that the defendant was looking at the bag?
The second time, he stoops down. He's a very tall officer. He stoops down 2 times.
Yes.
First time, he sees the officer looking over his right shoulder into this area in the back of the vehicle. The second time, he says, I saw him do that, quote, again, and at that point, I noticed
What's the point
bag.
of bending down and going in? Is he already intending to search?
No, Your Honor. He is concerned because the defendant is not getting out of the car. He's not listening to Officer Kaler. Officer Kaler's tone of voice alerted Officer Loud that something was going on, and he just wanted to bend over.
He says this, that he suspected he thought he was looking at the car while the defendant is in the car.
I'm sorry?
Is that what, I'm sorry, am I misunderstanding what you say the record
While
is?
the defendant is still in the car, yes.
This detective says, I saw him looking at the bag.
It appeared to me he was looking at that bag. That's a
At the
direct
bag,
quote.
not the area, at the bag
Yes.
itself. Okay.
That's correct, Your Honor. And that's consistent with the lower court's findings. The trial court found that, and the appellate division's findings of fact were absolutely consistent with that. And the facts in this case are very comparable to People versus Mundo. You have the same type of traffic infractions that are demonstrating dangerousness to civilians.
What would not have been enough in this case? What would not have been enough to do the search?
Well, Your Honor, you would have to, it's based on the totality of the
I understand.
circumstances.
What would reduce this below that threshold? Which of the factors you've outlined?
You would have to have a lack of an indication that a weapon is present in the vehicle.
Well, what would that mean in this case?
In this case, that would mean that he wasn't looking around the car, he wasn't looking at,
So he's got to look straight ahead or look at the officer.
not necessarily, Your Honor, but he's repeatedly looking at the same area of the car in which contraband could be concealed in the back seat of the car. So that would change the analysis.
Thank you, Ms. Olive. Ms. Goldberg?
This was a routine traffic stop. My adversary pointed out that in Torres.
Did the officer say, I saw him looking at the bag while defendant was seated in the car?
The full context of that quote is somewhat ambiguous. He says, I saw him looking in the back seat, and I saw the bag, and I thought he was looking at the bag. So, but
Why
we
doesn't
have-
that give you record support?
Well, because looking at a bag a plain plastic bag in the back of your car, like Judge Stein said, could be anything. It could be something he's embarrassed for the police to find, not even contraband. It could be his
Isn't
life
the question
savings.
really whether the behavior would make a police officer suspicious? It doesn't say objectively that you have to be able to see the gun. What you have to say is this behavior enough to make me think that there's a dangerous weapon, that there's something here?
It's more than suspicious. I mean, Carvey
Okay,
said
it's
specifically
fine,
it
that's
has to be
fine.
substantial likelihood.
Fine, you're correct. So how are we to evaluate what a police officer thinks is a substantial likelihood of there being a dangerous weapon in the car in this context then? Tell me what factor you say is essential in that evaluation.
Something concrete that would objectively show that this was a weapon. This wasn't. This was a bag. That's all it was a bag. That's all
So you-
anybody
you-
could say.
Under that theory, then you wouldn't be able to use the behavior in the process of interviewing the defendant.
Well, we have a second piece. The requirement is substantial likelihood of a weapon that poses a specific danger.
Okay, well, let's just
So
stay with the question I asked you.
Sure.
Would you be able to use the behavior of the defendant in evaluating that objectively?
in this particular case, it's not
No,
enough.
in any case.
For the weapon, sure, yeah. I mean, I
You don't
think,
have to see the weapon, if it can be in a bag, and the behavior of a particular party could indicate that it exists, right?
Yes.
And you'd be relying, I'm assuming, by your experience and training as a police officer to make that evaluation.
yes. But just looking isn't the kind of.
No, I
behavior
agree with
that
you,
would
just
indicate
looking
it was a
isn't enough.
weapon.
I guess it's difficult at the Court of Appeals to judge it, but it's the repetitive looking, the nature of it, and it's that factual evaluation it's an imperfect approach.
I think,
Would it have been enough, under your analysis of what you're arguing, if they had observed him as they're coming up to the car, try to push the bag under the seat?
I think that
More
would push
akin
it
to the cases
closer
you're
to
talking
Mundo
about,
and
you're trying to
Carvey.
conceal the bag?
I think that would push it closer to Carvey and Mundo.
How is that more about concealing a weapon than concealing anything else? We're kind of back to this line.
Well, because I think it goes to Judge Wilson's question about reasonable suspicion and what this case is and the wrong standard by the appellate division, that there was, that would have given them indication of criminality, not
I
just
guess
nervousness.
what I'm concerned with is if it's the totality of the circumstances and you're talking about, well, if they push the bag, now it's enough, right? I thought your argument was it might have only been enough given everything else that has gone on. So if he's stopped at a stop sign, or didn't stop at the stop sign, excuse me, it wasn't sort of the speeding or something that's dangerous that way. We'll assume going through the stop sign didn't risk someone in the moment. And he pulls over without in any way struggling or fighting, obeys the police, sirens to pull over, demand to pull over, but he starts pushing the bag under.
Then-
Would you still feel the same?
That is definite, that would not be enough to search the car. Not
Thank you,
even
Ms.
close.
Goldberg.
Thank you.